Now may I request Madam Pinky Anand, Vice President, Bar Association of India, to kindly respond to the address.
Justice Banerjee, Prashant, Shyam, Anindita and all of you, one thing I'll promise you, I'll keep myself limited for the time being, and the reason is very clear. We have been given a broad overview of the entire subject in hand by each of the speakers, and Justice Banerjee has an amazing style. She actually addresses in a manner which communicates the issues across, right from personal detail to merging it with the statutory and the constitutional framework. So let me just share with you just a couple of small thoughts on the subject. We have various sessions ahead of us. The issues have been flagged, and we start from an area where data was considered not to be of any utility whatsoever, where data was not considered to be an asset. Today, not only is data a concept of privacy, but according to me, an issue of asset. It's become an asset. So just to share with you one or two of my personal experiences, so whenever I go traveling, particularly for conferences, whenever I come back, I change my password. Because once I am outside, the information is available to, it seems, to everybody, and therefore, for example, I had calls. So I looked at my phone. I was in London at that time, and I got a call saying, do you need money? I said, all right. So one of the ways of deciphering that somebody has hacked your mail is the language. It comes from Nigeria and other places. Unfortunately for me, some of my friends actually sent money. The money went somewhere and I don't know where it was. We thought about tracing it, but ultimately gave up. But we came to know who the good friends were. So these are the lessons one learns down the line. There was a time when we didn't have right to information. Then right to information became a statutory and a constitutional right, and it is safeguarded under the statutory framework as much as all the constitutional framework. Puttaswamy, I know Shyam was a protagonist for the petitioners, I was for the government. In Puttaswamy's case, the right of privacy emerged as a salutary right, no doubt about that. But at the same time, there was a contest between the balancing and conflicting requirements. That's what Justice Banerjee rightly flagged to say, we are here, the courts are here to safeguard. So ultimately, when you have a right, it must also be protected, it must also be safeguarded. It cannot be untrammeled either. So therefore, even Puttaswamy's judgment lays down proportionality, purpose, an object to be achieved with the entire situation. So privacy is not absolute. Privacy is also to give in, for example, in the time of COVID, we've had a question of data, COVID data being available to all and sundry, and it didn't come out as a conflict in the courts. I was thinking it probably would. But if you ask me, if that data had to be made available for purposes of safeguarding the health of citizens, it should have been. There's no question of any privacy rights overriding the concerns of health and security, not the national security only, but the security of citizens qua their health. So there are conflicting rights which have to be safeguarded. So thankfully enough, we have come up to a frame where we are trying to come up with the bill, the 2019 bill, as a consequence of the judgment, Justice Sri Krishna's committee, which brings up all the concept of consent managers, the regulatory authority, the fiduciary relationships, what kind of data is safeguarded. The kind of manner, Prashant, of course, voiced some concerns about the nature of the committee, but then Justice Banerjee, as I said earlier, has also pointed out the constitutional courts which are there to safeguard. So we need to work on these issues as far as we are concerned, and really speaking, today's Bar Association function is meant to inculcate in us a sense of thinking, a sense of belonging, a sense of judging, and a sense of challenging and analyzing, not only to say what the bill is, but what the bill should be, and possibly what we can do to make it better, to come out with a worthwhile piece of legislation and not a bad law, as Shyam said. So with this, thank you very much, everybody, and look forward to the later sessions with all of you. Thank you.
Thank you, Pinky ma'am. It was as spontaneous as ever. And when it comes to who are the friends, she has been a great friend of Bar Association all through. Now it's time for formal vote of thanks. it's time to express our gratitude to all the speakers on the dais, especially Justice Indira Banerjee, for accepting our invitation to be here with us on a holiday. Many of our friends did tell us that it's a day of Eid as well as Akshaya Tritiya, so can it be deferred? But many others, in fact, did suggest that it's such an important topic, it's good to have it on a holiday so that we can participate effectively. On the spirit of brotherhood, celebration, and on the spirit of Akshaya Tritiya, I think it's a good foundation laying that we are doing by virtue of this seminar, and we are looking forward to meaningful and more emphatic voices to be heard in the field of data protection, so that we ensure that in days to come we have got a good data protection law which actually protects us, which at the same time gives data but not too much, which allows the freedom to remain obscure if I choose to be so. Where you are not responding like a Pavlovian subject in a psychology experiment, responding and getting into the trap, but you are where you can maintain your dignity, your identity, and stand straight. So we are looking forward to a regime of data protection where we as citizens are not mere dots in the analytics models of various big data companies, but we remain as citizens to make the democracies and rule of law thrive. So we are looking forward to a meaningful session during the course of the day. And with this, I once again take the opportunity to thank all of you, especially the Live Law team, which is led by PV Dinesh. He's here along with his entire team. They are our media partners. When it comes to sharing data, I think they're sharing the data of this very function in live tweeting. Thank you for being our media partners and reaching out to a larger audience and conveying the voices and messages that are being spoken over here. So thank you for lending voice to us. Thank you to the Indian Law Foundation, which is our research partner. Thank you, everyone. Now, with this, I think we can close this session, followed by the first working session, that's on unpacking the data protection law and who watches the watchers, because a lot of concern was expressed in the first session, government surveillance power. We already have the chair for that session, Senior Advocate and Vice President BI, Mr. Chander Uday Singh. So I think we close this session. Thank you, everybody, once again, and we start with the first working session. I request everyone to kindly remain seated as we would immediately start with the first working session. I would request Mr. Chander Uday Singh, Chairperson for this session, to kindly come to the dais, along with all the speakers, Mr. Amarjit Singh Bedi, Shri Apar Gupta, Shri Anand V, and Ms. Ria Singh Sawhney. Kindly come to the dais. Delegate friends to kindly please come back to the hall so that we can start the first working session. on unpacking the data protection law and who watches the watchers, government surveillance powers. The session is chaired by Shri Chander Uday Singh, Senior Advocate and Vice President, Bar Association of India, and the speakers are Mr. Amarjit Singh Bedi, Shri Apar Gupta, Shri Anand V, and Ms. Ria Singh Sawhney. I think all of them, we keep reading their articles and pieces in various places. It's time to hear them live. Over to you, sir.
This is the sequence. Amarjit, followed by Apar, then Anand, and then Ria last. Morning, good morning, and welcome back, all those who stepped out for a moment. I'm not going to take any time at all because I'm absolutely agog, waiting to hear all these amazing speakers. I'll just give you a very quick introduction to the panel right now. This panel, in the context of today's subject and the data protection, the proposed data protection law, this panel is nothing less than stellar. It's these are the stars of the on this subject, and so I'll start. Our first speaker is going to be Amarjit Singh Bedi. Amarjit is one of the leading advocates on record. He was also a gold medalist in the Advocates on Record examination. Represents a large number of corporate groups, including Reliance and Tatas and so on and so forth. I'm not going to enlist them all here. His forte really is arbitration law and commercial law, but he has been spending a lot of time of late in areas of privacy, data protection, right to information, and so on and so forth. He's also been assisting, in the administration of justice, especially information technology rollouts and all in the courts and so on. The next speaker, Apar Gupta, is his reputation and fame precede him because he's really dedicated the last almost a decade of his life to issues of privacy and the internet and the interconnection between IT and privacy issues. Apar is very young in legal terms because he's only been about 15 years in practice. He's 38 years old. He has worked after doing his masters in Columbia. He worked with Karanjawala and Company, worked with, then became a partner at Advani and Company. And finally, from 2013, he's worked almost exclusively and very extensively in the interaction between technology and civil rights, and where technology sort of encroaches or tramples upon on civil rights and so on. He has had actually this period when he got into this field has also been a very fertile period for the development of law in the Supreme Court. So Apar was involved personally in the development of cases as member of teams working in Shreya Singhal on Section 66A, in Subramaniam Swamy versus Union of India on the issue of criminal defamation. Of course, one day I'll sit down with him and ask him to explain me the language of that judgment. Anuradha Bhasin on internet shutdowns, very, very, very crucial judgment. Justice Puttaswamy, of course, on privacy, and the entire the whole line of Aadhaar judgments actually leading to Puttaswamy. He's also been working on as an activist actually in the field where he is heading teams on research, writing, and actively engaging with legislature, with the parliament and so on, as an advisor, as an expert witness, and other things. He deposed before the Parliamentary Committee on Information Technology, Science and Technology. He's worked on the DNA bill. He's worked on a lot of policy making and legislation. So I really, one is really waiting to hear Apar. Anand, I was just introduced to him. I have heard so much about him. Anand is Anand Venkatnarayanan. He's a cyber security and privacy researcher. He has extensive experience, not just in cyber security, but also in the hardware. So he brings a very unique sort of expertise in hardware and software. So I find from the note that he worked extensively at AT&T, Intel, NetApp on domains such as telecom protocols, network engineering, device drivers for graphics chips, Linux device drivers, file systems, storage management protocols. So it's a very unusual to have a person who is now at the forefront of the issues like hacking and privacy, but who brings a hardware perspective. I mean, he has the hardware expertise, which then can sort of intermeshes with what actually happens in terms of hacking and so on. He is a public technologist. He's written extensively about cybersecurity issues in a number of publications, peer-reviewed as well as popular publications. He was the first one to break the story of the hacking of the Kudankulam nuclear reactor in the public domain by North Koreans using something known as a D-track malware. So Anand was the one who actually broke that story into the public. He was called as an expert witness before the Supreme Court of India in the Aadhaar cases, and has also deposed before the Kenyan High Court in their digital identity project. I was just told by Shyam that Anand has also recently deposed, but I leave him to tell us more details about that. But he has also deposed in the Pegasus matter before the expert committee constituted by the Supreme Court of India under the chairmanship of Justice Ravindran. So we're going to get another very unique and very well-informed expert opinion from Anand. The last speaker, Ria Singh Sawhney, is a young and absolutely brilliant public interest lawyer who is a lawyer and a researcher who works on data protection, privacy, and issues like Aadhaar and so on. But what is very unique about her is that she has had extensive educational experience as well as in the field experience at the absolute frontiers of human rights issues with the atrocities against Rohingyas in Myanmar. She's worked with the UN Special Rapporteur on extreme poverty. So Ria, after getting her undergraduate degree in philosophy at St. Stephen's in Delhi, got a law degree from the law faculty in Delhi University, then an LLM at Columbia Law School, which she attended as a human rights fellow. She's worked at the Center for Human Rights and Global Justice at New York University, where she worked with Professor Philip Alston, who was the UN Special Rapporteur on Extreme Poverty. She's also worked as a consultant with several international agencies on privacy issues, and worked with Access now as a fellow. So I think we've got a galaxy of very, very learned, knowledgeable people, and I'm not going to stand between you and the speakers. So I'll call on the first speaker, Amarjit Singh Bedi.
Thank you, sir, for the kind words. Before I give my presentation, I just wanted to give you a background about how I came across my first-hand experience of computer. That was way back in 1985. So my father bought a PC Junior. It was called a PC Junior because it used to have a 286 or 8088 processor. And he started creating his database on a software called DBase 123 Plus, which was, I don't know, it was a DOS-based system. And he kept all his files on it. So the first data breach that I recall of is when that floppy drive was stolen by his employee. and entire data was stolen. So that was the first experience of data breach. And the second was when I was doing my law. So I was doing also working as part-time in Pune. I was doing in Symbiosis, I was doing my law. So when we had free time, I used to do part-time work, and BSNL had introduced internet in India. So they had two packages. One was TCP and one was DOS-based package. And my job was to go and teach how to use internet, how to connect to internet, how to put in the password, how to browse and use a software called Mozilla Netscape browser or something, I don't recall exactly. And the data theft that time that I recall was that a lot of employees used to steal the password because there were fixed number of hours. It was very expensive, probably 15,000 rupees for 20 hours or 50 hours of total internet package. And people used to steal that. So that's the second experience of mine of data theft. And then the last or the recent understanding is when I was working as a domestic consultant for Asian Development Bank in the project for access to justice in India, where we were interacting with various courts, district level courts and high courts, to introduce technology which will help the judicial system in probably a backlog, reducing the backlog of cases, streamline the processes, make it more efficient. Case management, make it more efficient, and help the judicial system make it more refined. So I remember interacting and working with Justice Aggarwal, Justice M.K. Sharma, Justice Lokur, and other judges from High Court and district courts. So there, when we were interacting with all these judges, and we were getting first-hand experience of how data is being treated. It was not at all, there was no concept of data at all. Means files were lying around, they were given for scanning, files were given to third party, there was no confidentiality, and the files were given outside the court premises where they would copy the file and bring it back, and that data was scanned and then recorded and kept in a CD, which CD would sometimes not work, and the entire process would have to be redone till the time somebody realized that no, we should put it in hard disk, or we should use pen drives. I think pen drives were there by that time. So that's how the experience, my experience with data access, data breach, relevance of data has come. And I am very interested in this subject, and I look forward to this bill taking final shape, because it's still a bill, and I hope that there will be a lot of amendments, and speakers after me will be able to get to the nuance of what are the difficulties and problems that especially section 35 and other sections of the bill, which we will face if it is actually become an act, because then government is totally outside the purview. With one single order, they can exclude or exempt agencies, government agencies, from the purview of this bill. So just to give a background about how the privacy laws have developed over the years, the first 1948 Universal Human Rights Declaration, privacy was one of the fundamental rights which was adopted, and I think it was the 12th fundamental right there, that right to privacy, which has now, as already elucidated, that in both Puttaswamy Judgment 1 and then 2, that is Aadhaar, and then subsequently in our right to privacy is one of the fundamental rights. And based on that, thereafter, this the need has been felt to protect our data, to protect our personal information which is out there, which we are so casually disseminating. When we have to apply for a loan, they will ask us to send all your data on a WhatsApp, and we very comfortably WhatsApp our data across on a mobile phone without realizing how this data is now being shared. I was reading an article that the government, Ministry of Transport, shared our data, our confidential data, with about 60 agencies or different agencies, including insurance companies, including business banks, including third parties. And that is why perhaps all of us get a phone call before our insurance is due, that do you want to renew your insurance, and that personal information was sold out. So today, as of now, there is no central one common law, one common act which takes care of everything. I call it, there is no Lord of the Ring. There is not one ring which controls all the other laws. There are various laws existing. For example, as Justice Banerjee was saying, under IT Act there is section 43A, which takes care, which protects to little bit, it takes care of it, or section 72, or the 2011 regulations. But there is no one comprehensive law. Maybe if we are defamed or we are done something, we can file a online defamed, we can file a complaint under section 500 seeking defamation. But there is no one law where we can go and seek our remedy. If our data is leaked, we may perhaps file a consumer case, or there are RBI directions which are given from time to time to banks and NBFC to regulate how the banks have to maintain or keep our data, or under insurance regulatory or different other regulatory authorities, there may be some regulations or directions which are passed from time to time which will take care of protecting our data, but there is no comprehensive law. So as Mr. Divan was saying, that it's better not to have a law, bad law, than to have no law, but we still need a law to protect and have it under one umbrella. And for that purposes, what I was trying to say is that from 48, when the first Universal Human Rights Declaration was adopted, subsequently in 73, the first data protection law was adopted by Sweden, and so on and so forth. Finally, the GDPR, that General Data Protection Regulation of EU of 2016, from which our data protection bill is quite inspired, but then they have made a lot of changes, keeping in mind the sensitivities and the requirement for our country. So, just going forward, why do we need a law today? India is the second biggest consumer of data after China. Every day they say that 2.5 quintessential bytes of data is being generated every day. And every day there is a privacy breach. Every day there is a data breach. Every day we are facing some problem or the other which we don't realize, or we take it so casually. For example, if we are accessing a website and you see at the bottom of the foot of the page, accept cookies or something like that, and we are, without reading, we are accepting it, because if we want to access the web page, we have to click that, and then when we go inside, we find that our data, our personal information, whatever we are sharing, is now going to that data controller or that data fiduciary. And we don't know how to get back if the data is unknowingly given to them or knowingly also given, and we don't want them to retain the data. How do we tell them to stop using it? So there is no law right now which takes care of it except the proposed bill. And I will come down to the brief or macro level points of what are some of the highlights of the bill which will regulate our data protection. Further, the way we are doing business today, the convenience. We use Paytm, we use online banking, we book tickets, we access or do online shopping. All our data is now with these big businesses or big companies which have access to our data, from Google, from Facebook, from Book My Show, from Paytm, from banks. They have access to our data. So it would inspire confidence and it would give us strength if we know that there is one act or one legislation which regulates it and our data will not be misused, and if it is misused, there are remedial measures to protect us and there are measures to undo the damage which has been caused. I don't know if you remember a story about an American adult website where the data was, the personal data of a lot of people was revealed in the public domain, and it led to a lot of loss of reputation for people of repute in the society. And similarly, when there is a breach of data, when your confidential business data, financial data is breached, somebody uses your credit card information to buy something, you get an alert on your phone that you realize that somebody is shopping using your credit card. Now you are sitting in the conference and somebody is buying stuff on your account or on your bank details. So that is a data breach. Now that is causing you a financial loss. How do you protect? How do you save yourself? The simple remedy would be to go to a local police station and register a complaint. But how often do you see any remedy from there? And how effective is it? So there has to be a system of convenience, just like online application form. You can upload, or you can approach an adjudicating authority, or you can approach a data control or data manager or control manager who would look at your look at your complaint and deal with it and resolve it. Today, if I personally am facing a problem that I have linked my FASTag with Paytm, but every now and then I keep on getting messages that my FASTag is used in Chennai, in Kerala, in different places, and there is no helpline number or there is no system from where I can call up Paytm and tell them that I am facing this problem. So the only resolution is I have to send these messages with the screenshot that my vehicle is parked in my basement, but it is showing as if it has just crossed a toll in Pune or somewhere like that. So kindly resolve it. So there are these problems which are existing right now, and which requires a central or one umbrella legislation which can take care of all that. We have also found that apart from that data which is shared with, which is disseminated, it is also that the data has got a lot of value. As Ms. Pinky Anand was saying, data has got an intrinsic value. They also treat data now as precious as oil. Why? Because data can predict behavior. So when we are browsing, and for example, if we are looking to book tickets for, let's say, going to Bangalore. Now when we are surfing and we stop our search, and then we later on go and open our phone or maybe a different device, the device knows that you are looking for booking a ticket to Bangalore. They will start giving you advertisement, which are targeted advertisement relating to hotels in Bangalore, what you can buy from there, speciality of Bangalore, etc., etc. So this data is now such a big tool that it can be used to target, it can be used to analyze, it can be used to predict. And this large data means a data which has got lot of volume, which is for example Google or Facebook, the kind of data they are accessing, and with their kind of knowledge, how they can manipulate or use it with their algorithms, with their artificial intelligence, the sky is the limit. And tomorrow, if there is no legislation to regulate it, we will be at a point where all our data will be with them, and we have this fear that this data may be misused, and there is no recourse. Thankfully, Google has an office in India, Twitter has an office in India, Facebook has an office in India, but imagine a big company which is controlling your data doesn't have a local office. And if there is no office here, how do you regulate it? How do you instruct that company to delete the data, or to return you the data, or to not misuse the data, or not to sell the data? So until and unless there is one law which will take care of that, and which I'll touch upon it in the latter part of my thing, that it is imperative that there should be a law, and it is imperative that the law takes care of all these issues which we as individuals will face in the future. Even today we are facing it, but we don't realize the import of it. Our data is being used by government extensively. Some of the examples: Aadhaar, passport, driving license, GST, income tax, UPI, Unified Payment Interface. All this data is now with the government. Now the government has access to this data, and this data can be used by the government to survey, to do surveillance, to predict, to even find out what is the pattern. If in a particular area there are people who are living, what kind of lifestyle they have, where do they go for holidays. There is a thing called NAT grid, that is a national grid. It has access from 21 different citizen data which is available with the government. So NAT grid is providing that access to the investigating agencies like CBI, to ED, to NIA. They have real-time access to our data. So they know exactly who you are talking to, what time your cell phone was on, where were you located, because all these data are linked with for example, mobile phone companies. Now they are providing the information to NatGrid, and NatGrid can then further share this data. So today there is no barrier. Data is freely being shared with all these agencies without our knowledge. So tomorrow, if you go abroad and you don't declare it in your income tax return that you had taken an extensive holiday in, let's say, Europe, the income tax authorities know because of these the various different agencies from which they are getting. For example, they are tied up with the immigration office. They are tied up with the travel agency. They are tied up with GST department. So if a travel agency is issuing you a ticket and a GST amount is deducted there or added there, this information is being collated, and then they're using artificial intelligence with sophisticated algorithms to use this data to predict your behavior, to predict where you're going. Everything is under surveillance. These, if you've been around Delhi, for people who have come outside from outside Delhi, please have a look. When you're traveling around, you will find cameras at every nook and corner now. So these cameras have got real live data of us. If my car is going, they capture the photographs that your car is located at this point or that point, and don't know exactly where you are, or at least your car is there. So this data is being exchanged, they are being used by NatGrid, and then NatGrid in turn is further giving it to agencies like IB, CBI, ED, RAW, everywhere. So having said that this kind of data is with them, what happens when there is a breach? When this data is leaked? So as I was just giving example, when the data is leaked, there are consequences. Either the consequences in the nature of a loss of reputation, if your information was with a confidential site, which you would not like generally to share with people, that you are a member of a particular site, and that suppose you are a married man and having an account in Tinder, and tomorrow that your data is revealed in the public. So you may have some problems at home, and you may have other issues relating to data breach. Or if, as I was saying, you are traveling, you are in Delhi and your data is being accessed at your hometown, and your some shopping is taking place and you don't even know, and you have a balance of 10,000-15,000 rupees there, and you realize I'll be eating out today, and you see your account, there is nothing left in it. So these kind of data breaches needs to be stemmed. There needs to be a resolution mechanism, and educate ourselves how to protect that. I have certain information. I have just collated certain instances of data breaches. In 2018, 200 government website accidentally leaked our Aadhaar detail, and hackers were selling this information for 500 rupees. So if somebody wants your Aadhaar details, he doesn't need to apply or go through a proper channel. He could have bought it for 500 rupees. So that's one of the breaches that we know of publicly. Then there is the Election Commission's data breach, where the voters list was hacked and it was available in public domain. Domino's customer database was hacked in last year. Air India's customer database, Big Basket's database were released or leaked in the dark web. So our data, which we have confidently given to a data controller, is now if it is breached and it is sold in the open market and it is being misused, we are not even aware about it, and we don't know what is the way to secure that. What is the way to right now, under the current law, it is very difficult because we have to take different remedies. And if you go to a lawyer and say, my data was stolen from my Citibank account, please give me a remedy, we would generally tell them, okay, let's file a police complaint, or maybe we'll say we file a consumer case seeking damages for whatever loss we have received. Another example is that Cambridge Analytica. You must have heard about that last year, and in fact that company has gone bankrupt because the data which was given, our data which was with Facebook, was shared to Cambridge Analytica without permission or our consent. And they were using the data, they were data mining, and with their algorithms they were giving a pattern to, it was used by Ted Cruz, the senator of US, one of the senators in US, who was contesting for presidential election. So he used Cambridge Analytica's data of almost 75 million people to campaign, to focus his campaign depending on the behavior or of the citizens to which is his vote. So what do we expect with a data protection law to do? We expect, I think I'm running short of time, I'll just conclude now, that we expect this data protection law to protect us, to give us a right to delete our data when we don't want a particular a data controller or data fiduciary not to have it. We want that our data should not be transferred or illegally given to somebody else. We want a right to be forgotten if we want to. But again, these are subject to caveats. You cannot be forgotten if it is in public domain, and for journalistic purposes, there are certain exemptions to them. So on and so forth. There are a lot of good things which are there in this bill which can help us, except that the government has all pervasive control under this bill, which needs to be diluted and we need to be protected. Otherwise, the benefits will not, the downside will outweigh the benefits under this act. Thank you so much.
Thank you. Thank you, Amarjit. I'm sorry, we just need to compress it a bit because the first session went about half an hour beyond time. So Anindita, I'm going to actually ask for about 15 minutes of the lunch time so that we don't curtail all the speakers, right? I'll now call on Apar to come in.
Thank you so much for having me here, and I hope I'm audible at the back as well. Yeah, thank you. So in the interest of a working session, I'm going to make this address a bit more granular, and I've seen that they've provided copies of the data protection bill as well. So I'll be referring to certain page numbers. You can go along with me. And firstly, just picking up the title itself of this working session, Unpacking the Data Protection Law and Who Watches the Watchers, Government Surveillance Powers. So we're trying to cover a lot of area here, and it's not an expectation I'm setting that I hope even this panel may not be able to unpack all of the data protection bill. This will require continuous work and different lines of analysis, given that it's a lot, right? If you read right on the first page itself, which is the objective of the bill itself, it's serving several objectives. And if you see the underlined and the bar, which is also put in bold, one insertion, and every part which is made through an underline and is made bold is the insertion made by the Joint Parliamentary Committee, actually. There's one insertion you'll see is to ensure the interest and security of the state. And this is what I want to focus on today. I don't want to deal with what are the economic aspects. I don't want to deal with a lot of it, because I think the stage which has been set here is also a question which is being prompted, and I think people are referring to it again and again. Can this bill in its present form actually provide a degree of benefit, or it hopes to actually formally and legally authorize certain existing practices that tilts the power away from the individual in favor of the state towards security functions, which may be exercised in an unaccountable manner but recognized by this law? So that's the question I hope to address. So the first thing, just in terms of the title of the law, if you see, it's been changed. It's the Data Protection Bill now. Personal has been dropped, right? And that's because if you notice section 2D, which is on page 2, it's referring to anonymized data. Now, a personal data protection bill usually applies to data which is identifiable against an individual, against a person, natural person, right? But once you also have anonymized data, data which cannot identify an individual against the data derived from that individual and is anonymized, it covers a larger ambit. Hence, the word personal has been dropped, and this does have consequences. I hope subsequent speakers can also touch upon how anonymized data, which receives lower degrees of protection, can also lead to re-identification. For instance, if a person knows through anonymized data where you're traveling every day, right, down to a very specific location but does not know your name or your identity, they can decipher that easily if they get other markers as well which are anonymized. For instance, age, gender, right? So going to the definition of personal data, it's on page 6 in section 333. This is the benefit of being lawyers actually. We get a dictionary every time. So if you go to page 6, you'll see what is personal data. Personal data means data about or relating to a natural person who is directly or indirectly identifiable. So anything which identifies you is personal data. And then certain specific subclasses which have higher degrees of sensitivity and require more regulatory oversight are what are termed as sensitive personal data. That's on page 7. Just flip the next page. Subsection 41, sensitive personal data, financial data, health data, official identifier, sex life, etc. These are not defined, so we don't know what this means, and more categories can also be added. But this is a good thing, right? It gives us more protection. Now, in terms of how this data and what is the application of this law is the first question to understand. Can this law actually result in reform of our surveillance framework? The answer is a clear no. This only applies to consensual forms of sharing of data, which is data processing. Skip up, subsection 36, same page, page 7. It applies to processing, and I'm reading out processing. Processing in relation to personal data means an operation or set of operations performed on personal data and may include operations such as collection, recording, organization, structuring, etc., etc. This processing can only be done by consent. At least that's the primary principle under this law. Hence, surveillance which is done in secret without the knowledge of the person, hence they will never be able to give consent, is outside the ambit of this law. And I am not the one who's stating this. Justice B.N. Sri Krishna, in the report which accompanied the draft bill in 2019, states this. First, he states, how is intelligence gathering happening? And I quote, much intelligence gathering does not happen under the remit of the law. There is little meaningful oversight that is outside the executive, and there is a vacuum in checks and balances to prevent the untrammeled rise of a surveillance society. End of quote. However, the same committee then goes on to note that the purview of the Data Protection Bill is not to reform surveillance practices in India and is limited to consensual sharing of data, which is data processing. Now, where is this consent coming from? And quickly you can look at it, is in chapter 2. If you skip to section 5, which is on page 8, I think so. Yeah, every person processing personal data of a data principal shall process such data, and if you skip to the next page, and if you look at B, for the purpose consented by the data principal. So there's consent there, right? It's I think so it's the very basis of processing, and this becomes clearer in section 11. If you skip to page 11, the personal data shall not be processed except on the consent given by the data principal at the commencement of its processing. So from the very start you have to do it. If you look in the middle between 5 and 11, you'll also find how consent has to be obtained in a legible form, in multiple languages, through intelligible notice. All good and well. We are going all good and well, right? It seems like a perfect law right now, doesn't it? Now let's read further. There's a chapter on exemptions. First, the ambit of the law, as was just adverted by Amarjit Singh Ji, is substantially restricted prior to even clause 35 in certain conditions where consent is inapplicable. So if you look at clause 12, which is on page 12, it contains chapter 3, grounds for processing of personal data without consent. This starts from the top. Now, a lot of people with whom I've debated, they have said that this kind of clause also exists in the General Data Protection Regulation in Europe. What's the problem in India? Okay, but let's read it closely. Notwithstanding anything contained in section 11, the personal data may be processed if such processing is necessary. What's the word? Is necessary. But what is the legal standard? Let us think back to the Puttaswamy judgment. Is it just necessary or is it also proportional? Is it also reasonable? And what you will find all through the data protection bill is the absence of the word proportional. And this becomes important for all of us as lawyers because each word means something. Going forward, you will see clauses 13, where necessity is again emphasized in certain other classes, that notwithstanding anything contained in section 11, which is the consent, subject to provisions contained in subsection 2, any personal data, not being any sensitive personal data, may be processed. So 12 is applying to primarily to state entities, 13 applies much more broadly, and if you look at 14, notwithstanding anything contained in section 11, personal data may be processed if such process necessary for reasonable purposes as may be specified by regulations after taking into consideration. Pause. Who makes the regulations? Who will make the regulations? Yes. So let us come to the authority now. Who appoints it? What are its functions? And in fact, what are its powers? So the powers of the DPA, before I come to the powers of the DPA, let me just come to clause 35. Let's read that also once. If you can skip to page number 30. Clause 35, notwithstanding anything contained in any law for the time being in force, where the central government is satisfied it is necessary or expedient, no mention of proportional. Clause 1, in the interest of sovereignty and integrity of India, the security of the state, friendly relations with foreign states or public order, these seem like standard 19(2) grounds, for prevention of incitement to offense or cognizance offense relating to sovereignty, integrity, security of state, foreign relations, foreign states or public order. Now read what's below. It may by order for reasons to be recorded in writing direct that all or any of the provisions of this act shall not apply to any agency of the government. Now the exemption is not limited to a particular activity, to a particular case instance, to a particular period of time. It is applicable en masse. So through a government notification, just like a government notification which authorized 11 agencies to conduct surveillance, they can in further of that be exempted. But those 11 agencies are not even within its purview. So what will be exempted? And this makes me think it may be the National Informatics Center, which has launched projects such as Arogya Setu. And what is the natural consequence of exempting Arogya Setu? I will come to a little later. And this becomes relevant because we are all still wearing masks, right? So is Arogya Setu useful? That's a separate question. But for us as lawyers, what becomes important is what is the legal regulation now? And will that regulation come when the data protection bill is passed into law, if it is ever? Now, if you look at the question which was being put earlier and the response I was getting about who enforces this law. After all, this law will not enforce itself. It is the Data Protection Authority. So clause, and we quite often know as lawyers that the independence as well as the powers of an authority quite often depend on its independence, on its autonomy, on its ability to administer its function and powers without fear and favor. And a good initiation to that, as is also visible in several litigations before the Supreme Court, directions which have come, has been on the point of selection committees. So if you look at clause 42, it specifies the committee which is tasked with the appointment. It's on page 35. Is tasked with the appointment. Now the chairperson and members of the authority, I think it's 6 in number, and the chairperson of the selection committee for the Data Protection Authority is the cabinet secretary. I would invite all of you to study the functions of the cabinet secretary and what do they do under the surveillance regime we have. And you can look at other members, they are certainly independent, but look at the powers of the central government in the appointment. Now, a director of any of the Indian Institutes of Technology. How many are there? A director of any of the Indian Institutes of Management to be nominated by the central government. How many are there? So let's think about it a bit more pragmatically based on our experience of how we have seen the law actually play out. But this is not all, and I will end here with the work I've prescribed here. It's with reading of clauses 87 and 92. So let's skip to the back. Page 59. Power of the central government to issue directions. To whom? The Data Protection Authority. Section 87. The central government may from time to time issue to the authority such directions as it may think necessary in the interest of sovereignty and integrity of India, the security of the state, friendly relations with foreign states, or public order. 2. Without prejudice to the foregoing provisions of this Act, the authority shall in exercise of its powers or the performance of its functions under this Act be bound by such directions as the central government may give in writing to it from time to time. Now, what is even more concerning, and I'll just come to Arogya Setu, why that's important, I'll give a practical example to all of this, is section 92. Notwithstanding, anything in this Act shall prevent the central government from framing any policy for the digital economy, including measures for its growth, security, integrity, prevention of misuse, and handling of non-personal data, including anonymized personal data. The central government, in consultation with the authority, may direct any data fiduciary, so and so, so and so. So, by policy making power, if this bill passes into Act, the central government can make policies, and this Act itself is stating that. And a policy does not need to be tabled before Parliament, and quite often it's a very inefficient function for us then to approach court, and then for the government to claim before the court that it has done so in consultation with the Data Protection Authority. Is this efficient? And that brings me to Arogya Setu. What is Arogya Setu? Arogya Setu is a digital contact tracing application. It's been downloaded more than Pokemon Go, as per statements which are repeatedly being made. And many of you may think that what are the practical consequences of downloading Arogya Setu beyond surveillance? Even if Arogya Setu is junk, it's just one other app on my smartphone. Besides Google, Facebook, the government also knows some data. But take, for instance, the diagnosis given to Jitendra Machar from Ghatkopar, Mumbai, and this is an instance reported in February 2021 by midday, where Arogya Setu diagnosed him as positive for COVID-19 and continued to do so till February 2021. What are the practical consequences is loss of business, inability to travel, and also the real inability to also conduct much of their life. In terms of any grievance redressal process, if it is made only through policies without a legally empowered act which can give them rights towards access of their data, which is in this, modification of their data, correction, etc., etc., what use is the data protection law? But here is what becomes problematic. The very basis of Arogya Setu is through a policy design, which brings me to the larger question, will this data protection bill actually result in the kind of benefits it promises? Even otherwise, I would disagree here, and I say this with regret to Mr. Divan, that the process of law is incremental. As much as I see problems with this law, I have lost patience after 15 years of my work. While he may not have aged, I have aged. At least, sir, you don't look like it. So, what I would say is that even if this law is passed in an imperfect manner, the basis of us actually improving the law is experience. It may be through litigation, in which it may be challenged before court. It may be through amendments by Parliament itself. And hence, I think so, this law has been belated, and even if it is flawed, may be passed. Finally, in terms of digital policy setting and laws which need to be brought out, a lot of issues are being bundled into the data protection conversation, which deserve independent examination, as are being done in Europe and other countries. For instance, Europe is looking at the Digital Markets Act, the Digital Services Act, the Artificial Intelligence Act, it has already made the e-privacy directive. But it did something much more important. It made the GDPR, implemented it, learned how it could not be applied in certain instances of harms, and then on the basis of that experience has gone forward. So, essentially, even though this act may codify certain improper practices, may not deal with surveillance reform, I do think it may be something useful at this present point in time. Thank you.
Thank you, Apar, for a really succinct summing up of some of the flaws as well as the possible aspects which might ultimately need to be set right at some stage if this becomes a law.